Ron Klain is going to join us, who's our moderator today. He is en route from the airport, so he will come in over the course of our opening remarks. I just want to start by saying welcome on behalf of the American Constitution Society. As most of you, I think, know at this point, ACS is slightly younger than the Bush administration, and we are very excited to be proposing ideas for the first transition of power during the course of our organizational lifetime. Over the course of the last 7 years, ACS has become, as I think most of you really do know, one of the nation's leading progressive legal organizations. We have a network of lawyers, academics, law students, policymakers, and activists all across the country, 165 law school chapters, 30 lawyer chapters, and a series of publications, several of which you're very familiar with already, and of which the papers today have come from. Also 8 working groups, which have been the source of some of these papers as well, which on issues ranging from liberty and equality to separation of powers to democracy and voting. So a huge source of substantive ideas. One of our goals is to help develop and advance a vision of the Constitution, law, and public policy that gives full meaning to our founding values of democracy, rule of law, individual rights and liberties, genuine equality, and that is a lot of that is the guiding principle of a lot of ACS's work. And I think our best leaders have had those very same values as their lodestars. And I think the best of this country, in many ways, is reflected in the extent to which we have continued to progress towards the realization of those values. So with the inauguration of a new president in January, we wanted to focus on specific ideas and recommendations for how a new administration could continue to move this country closer to the full embodiment of those values. No matter who prevails on November 4th, the installation of a new administration is going to bring fresh opportunities to think anew and creatively about our national priorities, our goals, and how best to achieve those goals. So we reached out to our members and encouraged them to think deeply and broadly about how to address the many challenges that are facing our country today. And the responses were tremendous, in fact, very heavy, if you actually have one of those full documents in front of you. We're delighted to be releasing this series of papers today, and which set forth a range of ideas on critical legal and policy issues that are facing our country today. They are not only at the core of ACS's mission, but also, I think, fundamental to the future face of our nation. The papers address the role of the Justice Department in areas such as civil rights, criminal enforcement, legal advice to the president, liberty, security, and the rule of law in the post-9/11 era, environmental law and policy, workplace fairness, government transparency, and the regulatory process. Needless to say, these issues are near and dear to all of us and could stand some rethinking. Quite seriously, the next administration really will face, regardless of party, some daunting challenges in reforming our law and justice policies, in bringing the Department of Justice's reputation for integrity back. The proposals discussed today provide a roadmap, as well as, we think, some very specific tools for doing just that. And we are excited to be focusing attention on these proposals and hope that they're very seriously considered by a new administration. To augment the release of these papers, we have a terrific panel today featuring several of the authors of the papers, all of whom are experts in their fields. And we're looking forward to a terrific discussion among all of you. And I want to say welcome and thank you from me for being here. Hello, Ron Klain. No, I warned everybody that you were coming in. And our moderator, Ron Klain. To lead off the discussion, we are honored to have Representative Donna Edwards with us, who is going to deliver opening remarks. As anyone living in the D.C. metropolitan area knows, Representative Edwards is the newest member of Congress, having been elected to represent Maryland's 4th Congressional District in a much-watched special general election this past June. Representative Edwards is the first African-American woman to represent Maryland in the United States Congress. She is a longtime lawyer and community activist who has personally worked to make our democracy and our civil society as good as they can be, and I think in many ways has lived ACS's mission. She has used her law degree to serve the public interest for 2 decades now. She was the co-founder and executive director of the National Network to End Domestic Violence, an advocate for Public Citizen and Center for a New Democracy, and the executive director of the ARCA Foundation. In various media accounts, she has been called tenacious and smart, a very well-respected public servant, and devoted to progressive principles. The Washington Post described her as, quote, an effective, energetic advocate for a range of liberal causes, the environment, higher minimum wages, stemming domestic violence, campaign finance reform. The Post went on to say that she has won the respect even of those with whom she has differed on substance, as, quote, a sensible and no-nonsense adversary, and pronounced her, quote, unlike me right now, poised, persistent, and principled. I'm not sure what else we could ask for in a member of Congress. Representative Edwards, welcome.
Thank you, Lisa, and good afternoon. And I am going to prove Lisa entirely incorrect because I will neither be poised nor sensible, I think. I'm actually glad that Ron arrived because I sat there in great fear wondering how long I'd have to go on and on and on before you got here, so good call. It's really tremendous to be here this afternoon. As Lisa may remember, I remember when ACS started, and I was at the ARCA Foundation, and you know, a lot of proposals come by the desk, and I read it and wondered, was this something that really could work, where you'd actually pull together progressive thinkers about public policy, and they would give the sort of breadth and depth to really, you know, strong progressive ideas and advocacy. And it turns out that indeed it has worked. And so I congratulate you. I think as an advocate, one of the things that and an unabashed liberal, let me just say that straight up, the L word for me. But one of the things that I always struggled with is that as progressives, we would get together in our various organizations and advocacy organizations, and we'd have really, really great ideas, and you know, not the best sort of law and sound constitutional basis behind those great ideas. And it was almost invariably at the last moment that we'd say, you know, it'd be great to have a little law backing us up. And so I think it's really important that you are here and that you serve a really important purpose of taking some of these ideas and concretizing them, and grounding them in law and in sound public policy, and most importantly, and I think this is really critical for progressives, also grounding us in the Constitution and the value for the Constitution that I believe is the basis for so much of what we do and the way in which we do it. And so thank you for your work. Now, I graduated from this funky little law school in New Hampshire called the Franklin Pierce Law Center. And now that there's an ACS chapter there, I may not be able to describe it quite as just this funky little law school. But it turns out that another of my colleagues in the Congress is also a graduate of Franklin Pierce, and so now we're like officially on the map, all congressional and everything. I remember when I was in law school, and I also served as a trustee of the institution for about 10 years. And my role, frankly, at the law center and as one of the trustees was constantly promoting this idea that it was, you know, in fact, good and wonderful that we would train lawyers who were committed to the public interest and committed to progressive values. And I think now that it would have actually been really terrific to have an organization like ACS in the mix to really enliven and strengthen our debate. And so I support you in all the work that you're doing across college campuses and in our legal community to really strengthening the ideas that are so important to us. And I know that my passion, and this is to the many students who are here today, I know my passion when I went to law school, I actually lied about my passion because I had been a systems engineer at Lockheed working at Goddard Space Flight Center on the Space Lab project, work that I really, really loved. But when the Challenger blew up, and that was one of my missions, we were just kind of out of work for a long time, and I decided to go to law school, and I pretended to everyone that I was going to law school because I was going to study patent law, because that made sense from what I had been doing. And no sooner that I got there, and Franklin Pierce was actually had patent law and intellectual property specialty, but no sooner did I arrive that I just, threw all of that away and had this incredible passion to do work in the public interest and to finally do work for which the basis were all of those, liberal and progressive, I don't think we knew the word progressive then, but liberal ideas that I believed in and causes that I believed in. And so that experience has actually enabled me for the last 20 years to do work about which I am unbelievably passionate. And now I can take that into the United States Congress. And so that excites me. But I think, as I've discovered, I think I was sworn in, I don't think about it, but I was sworn in on June 19th in a special general election. And I had intended to have this lag time between a primary election and a general election, and then, moving into the Congress with this freshman class in January. I had intended to have that time just to think about things and to organize myself. And then we had this special general election. I was elected on June 17th, sworn in on June 19th, casting a vote like 15 minutes later, and have had no time to think. But it does occur to me as I have begun to serve that one of the things that we lack, I think, in the Congress is the opportunity to think through issues, to look deeply at them, to study at them, so we get these, critical challenges. But as members, it's really tough to find the time to think deeply about some issues that are, in fact, really important. And so I think the value of an ACS for our broader community, and certainly to me as a member of Congress, is to help that process along and to enable us to think in a broader way about the work that we're doing and why we're doing it, what it means to people's lives, and what the basis in law and fact is of the work that we're doing. And to enable us to chart different courses. And some of these ideas, in fact, are quite experimental, whether it's around women's rights and reproductive freedom, or workers' rights, or the election law and political process, that in some ways we're at a time of incredible opportunity for experimentation. And I think that we can certainly see in this election season, without even wearing any partisan hat, that we know that come January it will be a unique opportunity in our history to begin to transform our thinking. And we need you and a strong progressive legal community girding the work that we do. And so I'm looking forward to the future, but I also know that it can't be done in the best possible, that the work that we do can't be done in the best possible way unless it's really grounded. And there have been ideas that have been tried and true on a variety of issues over the years, and sometimes we actually forget those, and we need somebody to go back and look those things up. Last night I was watching the presidential debates, and John McCain and I think Senator Obama as well put out this idea of reinvigorating a homeowners loan corporation that had existed during the Great Depression and up until about the mid-1960s, I suppose. And nobody sort of knows about this. And yet we may be in a process of beginning to figure out important public policy. And then the question is, what is it that we've learned from our past experiences from law and practice that help us to figure things out differently and perhaps better for the future? And I know that those are things that you will be thinking about, and important to do that work now. I can recall as an advocate, particularly in my days at Public Citizen, but also the National Network to End Domestic Violence, and we would use this time period very wisely between sort of November to January, and especially as a new administration was coming in, because there's no better time to get your ideas into the mix and stirred around than there is this time period. And so I really do applaud the work that's gone into thinking through some new ideas and new approaches and getting those into the mix so that we don't find ourselves in the middle of June to to November next year asking where are the big ideas, and that will be important work to happen. And I look at where we've come over this last 8 years and think about some of our agencies, whether it is the Department of Justice, as we've just been talking about, I was talking about earlier, and that you've looked at, and thinking, how can we right this ship? So that we have a Department of Justice that's, affecting public policy in a way that is unbiased and independent as it ought to be, and that work can proceed, whether it's in civil rights or environmental enforcement or whether it's in white collar crime, but in a way that the American people can actually have respect for the analysis and work of that Department of Justice. And I think that this is true across many different agencies. And at some point or other, the history will be written of the last several years about how our government, its processes, and its interaction with communities has been greatly changed, and perhaps not for the better. And the time to right that ship, I believe, will begin come January 2009, whomever occupies the White House. I would say, of course, these days, many of us, if you pick up the front pages of the Wall Street, I had them all this morning, Wall Street Journal, Financial Times, Washington Post, New York Times, LA Times, they all say the same thing. And I think if folks out in our communities are picking up these newspapers and watching the news, it is a deeply uncertain time that requires aggressive strategies, not just around the economy, but around thinking about the future and thinking about the 21st century. And the 21st century, whether we're talking about energy policy or government oversight or the financial industries, and all of the things that the groundwork for which will need to be laying over this next couple of years that will last us for several generations. And so I will close now, and I looked as I came in, of course, at the leadership of ACS, and it was wonderful to recognize so many names of folks with whom I've worked over the years, and I think ACS has exactly the kind of grounding that we need to be thoughtful about the challenges that face us. And I wish I could stay for the discussion, but hopefully I'll catch it on tape or something. Thank you very much, and it's been a pleasure to be here. Thank you.
Thank you so much, Representative Edwards. It's terrific to have you here. Thank you. My name is Judy Applebaum, and I'm the Director of Programs at ACS, and I want to join Lisa in welcoming all of you here and thanking our great panelists for being here with us. I have two very quick tasks before turning it over to the panel. First, I want to tell you just a little bit about the ACS publications in which you'll find a number of the papers that we are releasing today. You'll see if you look through that thick volume that a number of the papers are being published in our two journals, one of our two journals. One is the Harvard Law and Policy Review, and the other is Advance, the journal of the ACS issue groups. Each of these journals is published twice a year, and all ACS members get complimentary subscriptions to both of them. They're only in their second year, and we think that they've already proven to be an important, both of them, important vehicles of progressive legal and policy ideas. In addition, some of the papers that we're releasing today are in what we call ACS issue briefs. They're short, accessible white papers that we electronically disseminate far and wide. Both our journals and the issue briefs address, as Lisa said, address a very broad swath of topics, from criminal justice to voting and democracy to constitutional interpretation to separation of powers to economic and workplace issues to international law and more. So if you're interested in seeing the publications, subscribing to them, perhaps writing an article or a paper for us, there's information on our website, and I encourage you to go there and check them out. Second, I want to say a word about the authors of the papers in this volume we're releasing today. The folks up here are just a small subset, a very distinguished sample, to be sure, but a small sample of the terrific roster of authors who have contributed to this volume. And I want to mention a number of the other authors and co-authors are here with us today in the room, and I'd like to acknowledge them and just ask them to signal their presence as I say their name, in part because we do have the press here, and if there are questions about papers that any others of you have written, it'd be good to make yourselves know. Jeffrey Kleinberg, I think, is here or was planning to be. Yep. James Robinson, Margaret Love, P.J. Crowley, Devin Chafee, Amanda Frost, Peter Swire, Lois Schiffer, I know is here. Cyrus Mary and Ellen Erdley co-authored a piece. Meredith Fuchs is here. Elaine Kaplan and Tim Hannipol are both here. And Michael Fitzpatrick, who co-authored a piece with Sally Katzen. So thank you to all of you who contributed to this. And now it's my pleasure to introduce our moderator, Ron Klain. Ron, I think as many of you know, has held senior positions in all three branches of government as well as the private sector. After graduating from Harvard Law School, he began his legal career as a law clerk to Supreme Court Justice Byron White. He has served as chief counsel to the Senate Judiciary Committee, chief of staff and counselor to Vice President Gore, chief of staff and counselor to Attorney General Janet Reno, and associate counsel to the president. He has been recognized repeatedly for his many achievements and named as one of the nation's top lawyers and leaders. We're proud to have Ron on the ACS Board of Directors, and we're delighted that he's here today to lead this discussion. So I'll turn it over to you, Ron, to introduce the other panelists and to take it from here. Thank you very much.
Thank you, Judy. And in case there are any lawyers in the room, I should say that notwithstanding my role as an ACS board member and a volunteer in the Obama campaign, I'm here today on my own behalf, speaking on behalf of no one but myself. I also want to thank, obviously, ACS for organizing this and for the fantastic task, the Herculean task of assembling the authors and the papers that are there today. And I think it's a tremendous piece of work that will be a great resource to the next president. I'm just thrilled to be part of ACS and our outstanding staff led by Lisa and Judy in this regard. It was also great to have Congresswoman Edwards here today. I'm glad she made mention of her time at Goddard. It once again proves that she is that rarest of combinations, a member of Congress and an actual rocket scientist. Before I introduce our panel and have them talk about their papers and their thoughts about the challenges for the next administration, and take your questions, obviously, I just want to say two very brief thoughts, two very brief introductory comments. The first is, although our topic here is broader today than just the Justice Department and legal policy per se, I'm often asked how things got as bad as they've gotten at the Justice Department and in the area of legal policy under President Bush. And after all, we've had very conservative presidents before, President Reagan, the prior President Bush. How did things get to be as they are? And obviously there are many factors that go into it, many individual decisions and individual actions. But my view is the one overarching theme over the past 8 years has been a view that legal policy doesn't differ from other sorts of policy, that the Justice Department is no different than any other cabinet agency, and that really there is no distinction between just law and politics or law and policy. And I think that sort of view, which we've seen writ large over and over again in decisions where the rule of law has been ignored and politics and policy biases have been allowed to take hold, really is at the core of the problems we've seen over the past 8 years in legal-related areas. And I hope and expect our next president, whichever of the two candidates wins, will reverse that. It's particularly ironic because I think anyone who's a progressive who's ever had to engage in a debate with a legal conservative knows that one of the first three epithets that's thrown at you is that liberals are, quote unquote, results oriented. Often it's epithet number one. And the fact of the matter is, I think when the history of this administration is written and done, in Black's Law Dictionary, the phrase results-oriented will now have a picture of the Bush Justice Department right next to it. And hopefully that's a legacy that the next president, be it John McCain or Barack Obama, will serve to reverse. The second point, by way of general introduction of the panel, and why I'm so happy to be here today and be part of this, is how this panel and the work in that outstanding transition volume differs from most other progressive discussions about legal policymaking and also from my mother's mahjong game. Now, my mother's mahjong game, which meets once a month, inevitably goes something like this. At some point in time, someone will say, my leg hurts so bad, you can't believe how bad my leg hurts. And then someone else will say, well, your leg is nothing, you ought to see my back hurts so bad, it's even worse than your leg. And so, well, it's not your back, my shoulder hurts so bad. And it's kind of an escalating competition of woes. And, and I think too much of our discussion about legal policy in the Bush administration, winds up sounding like that. You ought to see the criminal division, it's a disaster, you ought to see what that's like, it's horrible. The criminal division, it's the environment division you ought to see, it's horrible, it's terrible, and so on and so forth. And I think what's encouraging about today's discussion and about the papers that you're all getting today is though it certainly document the problems and what needs to be fixed, I think they are creative and innovative efforts to go to the next step and say, what can the next administration do right? Where can we go from here? Where can we not just complain about the past 8 years, but really move the dialogue and the direction forward? And so we're very lucky to have four very innovative thinkers up here with us today, many others in the audience, others still who wrote papers who can't be with us today, to really present a forward-looking, positive, affirmative agenda for the next 8 years. And so with that, let me start by introducing our panelists one by one. I'll introduce them just before they speak. And our first one, to my immediate left, is Bill Yeomans. And Bill is currently Chief Counsel to Senator Edward M. Kennedy, Senator Ted Kennedy, and authored an article in this package entitled Restoring the Civil Rights Division. I've had the pleasure of knowing Bill for a long time in many different respects, both at the Justice Department, where he's had an outstanding career in the Civil Rights Division, and also as Acting Assistant Attorney General and Chief of Staff, and a number of other positions. He also obviously has worked on Capitol Hill, and most near and dear to my heart for this purpose, worked with us at ACS for many years, and really, getting us going there and laying the groundwork for a lot of what exists at ACS today. So with that, there's really no one who has seen these issues, particularly around the Justice Department and the civil rights issues, from so many different perspectives with so much experience and richness as Bill Yeomans. And so with that, I will introduce Bill and let him talk about his paper.
Well, thank you, Ron. There's nothing like going into a talk with lowered expectations. First, let me say that I am here to talk about Senator Kennedy's paper. And to the extent that I stray from something that's on the written page, please blame me, don't blame him. And if I say something particularly smart, then please give him credit. That's not likely to happen. Let me start. I mean, Ron's given a good summary, I think, of an overview of sort of what generally went wrong with the Justice Department. I mean, as we all know, the Justice Department within the executive branch really is the guardian of the rule of law. And there is a distinction between policy and law that the department has to observe. Certainly, the president, the attorney general, the political appointees can set a policy agenda. That's their job. And, they can establish priorities. But when it comes to the actual application of the law to a set of facts, or when it comes to actually interpreting a statute, interpreting the Constitution to give legal advice, then the Department of Justice has to pay first fidelity to the rule of law. That's really the fundamental point where the department has gone off track too often in this administration. I'm glad to talk about other aspects of the Justice Department, but let me focus in first on the Civil Rights Division, since that's what Senator Kennedy wrote about. I think that it's fair to say that a number of components of the Justice Department have had a rough time in this administration, but probably none rougher than the Civil Rights Division. from the very beginning of the administration, after John Ashcroft was appointed as Attorney General, it became clear to the civil rights community and to people there that the division was in for some challenges. And, there was conservative literature, one notable article that appeared in the National Review that laid out an agenda for what needed to be done with the Civil Rights Division and what needed to be done to sort of clean out the career people, change the entire perspective of the division, and turn it around from this too progressive organization, I guess. And so what happened was that Ashcroft came in, he abolished the traditional system for hiring career attorneys, took it out of the hands of career people. The way it worked before was the career people interviewed, identified applicants, recommended people to be hired to the political people. Political people made the final decisions and rarely departed from the recommendations of career people. What happened under Ashcroft was that the entire decision-making process was consolidated in the hands of political employees. So for the honors hiring program, which is the way that young attorneys come into the department, the career people weren't seeing resumes and really had no hand in what was going on. So there was a sort of a political culling process from the arrival of the resumes. Political appointees did all the interviewing. Political appointees made all the decisions. After that change, and Charlie Savage has documented this very well, there was a very clear change in the kinds of people who were being hired into the division. You found that far fewer people coming in had civil rights experience. Far fewer were coming from first-tier law schools. Many more had conservative organizations on their resumes, and many advertised in association with the Republican Party. So this was a very conscious effort to restructure the career ranks. And the career ranks are important because they always have been the foundation, the institutional foundation of the Department of Justice, and the repository of this notion that there is fidelity to something other than the President's agenda. I think that one reason that this took place was that the Bush administration had learned a lesson from the Reagan administration. The Reagan administration came in with a desire to change pretty dramatically the enforcement of civil rights laws, but tried to do it with a kind of a top-down approach by setting priorities from the top, affecting what went into briefs, that kind of thing. But didn't work from the bottom up. And I think the Bush administration decided the change needed to come both from the top down and from the bottom up. So I think the goal was to remake the career attorney corps in the image of the Bush administration political appointees. And a lot of that happened. That kind of change obviously produced some enormous changes in the division's activities, the combination of top-down and bottom-up changes. So you saw a radical change in the priorities that the division pursued. Under Section 2 of the Voting Rights Act, for instance, which is the main proactive provision of the Voting Rights Act, the division went between 2001 and 2006 without filing a single case where African Americans were victims. There's a similar pattern in the employment discrimination realm, where the section simply backed away from pursuing any large-scale pattern of practice cases involving disparate impact, particularly if they involved racial discrimination. Also in voting, you saw partisanship creeping into the administration of Section 5, which is the provision that requires preclearance of electoral changes by covered jurisdictions, starting with a Mississippi redistricting where the division, without adequate justification, delayed a preclearance decision to allow a federal court time to enter a redistricting plan that was much more favorable to Republicans. The division pre-cleared the Tom DeLay engineered Texas redistricting in the face of a unanimous staff recommendation that it should be objected to as discriminatory. It pre-cleared the Georgia photo ID law in the face of an overwhelming staff recommendation to object to it, and that law was subsequently struck down as the equivalent of a poll tax. So we saw the effect of the change in the who was coming into the Civil Rights Division. Very quickly, what to do about it. Part of the remedy, obviously, is to get new leadership for the department and to change the tone. And whoever becomes president obviously needs to identify and get in place very early an attorney general and an appropriate team, which we hope early on will include an assistant attorney general for civil rights. And the attorney general, and I think it's helpful if the president says something too, need to make it very clear that the department will now be governed, will be the guardian of the rule of law, and that hiring within the department will be governed by merit, ideology, and partisan affiliation won't trump merit. That tone needs to be set very early on. I then think that, and Senator Kennedy suggested, there needs to be a comprehensive review of the hiring practices of the department, particularly in the honors program, the way summer law interns are hired. And it's a review that needs to include both political and career people. And it needs to look at the whole hiring picture, including what needs to be done to correct the situation that we now find. And I guess we can go into later, if people are interested, some of the possible ways that could be addressed. There also obviously needs to be a change in priorities. The new leadership of the department needs to take partisanship out of the administration of the Voting Rights Act. It needs to step away from using other voting laws like the National Voter Registration Act, like HAVA, in ways that very clearly benefit one party and disadvantage another. We need to go back to enforcing civil rights laws to carry out the core mission of the Civil Rights Division. And that core mission includes voting discrimination based on race. It includes using Title VII and other laws against employment discrimination in a way that gets the most bang for the buck and serves people who've been discriminated on the basis of race, national origin, and gender. And I think Lily Ledbetter has helped to put discrimination based on gender back on the national agenda, and that's something that the division needs to be very conscious of in the future going forward. So that's a kind of a quick overview, and I guess time demands that I pass it on, but I look forward to our discussion and to entertaining your questions.
Great. Thank you, Bill. Our next speaker is Deborah Pearlstein. Deborah is a unique combination of world-class scholar and someone with an incredible amount of hands-on experience with a lot of the most vexing and complex problems at the intersection of law and national security and civil liberties. She's now at the Woodrow Wilson School at the Law and Public Affairs program there. But before that, she was the founding director of the Law and Security program at Human Rights First, where she led the organization's first monitoring mission to Guantanamo Bay and co-authored a series of reports on the human rights impacts of U.S. national security policy. A classic underachiever, Deborah was a speechwriter for President Clinton before she went to law school, where she got her degree magna cum laude at Harvard Law School and clerked for Judge Bodine and Justice Stevens. So we're very lucky to have her here with us today to talk about her paper, National Intelligence and the Rule of Law, and the broad topics around these issues. Deborah?
Thank you. Again, I thought the whole idea was lower expectations, but that's all right. We can talk about that later. Thank you very much. I'm delighted to be here. I want to take just a few minutes, and rather than to summarize the paper, which you all have, and speaks in part in broad terms about how to think about law and its relationship to counterterrorism policy. I want to just, in the spirit of positive recommendations and thinking about how to move forward, identify what I think are how to frame the problems that we're facing in this area going forward. And I think, you know, we were asked to think about the 2 or 3 biggest problems the incoming administration or Justice Department has in the realm of law and security policy. And I think I would divide them into 2 categories. Problem set 1 is how to get the truck out of the ditch, which is to say how to correct a series of unbelievably catastrophic policy decisions that we now find ourselves still in the midst of unpacking post-2001. I include in that category certainly the detentions at Guantanamo Bay, but more broadly, the detention system that the U.S. continues to operate worldwide, certainly in actual war zones in places like Iraq and Afghanistan that pose special problems and challenges, but also, of course, the secret CIA detention program that I'm sure everybody is now familiar with based on its reporting and ultimately the acknowledgement by the President. So the detention programs, of course, perhaps most critically, the interrogation policies that we've pursued, and to some extent continue to insist upon our prerogative to pursue interrogation techniques that I think most lawyers, most scholars in international and constitutional law would argue are unlawful. And then trial system, most particularly the military commission system at Guantanamo Bay, for trying those who we believe have engaged in either terrorist activity or war crimes or some novel combination thereof. And all of these policies together have, I think, not only obviously deeply undermined the United States' reputation as a beacon of the rule of law and human rights, it has also undermined the United States' ability to promote democracy and human rights worldwide. We no longer carry the power of moral suasion that we once did for our human rights defender colleagues in places like Uzbekistan and elsewhere. And it has created, as I think an increasing number of security scholars say, enormous strategic problems and deficits in our achieving our security goals in counterterrorism. So how do we solve this set of ongoing problems? We're still at Guantanamo. There's still unclarity in our commitment to non-coercive or at least non-torturous interrogation policies. How should we try terrorists and so forth? That's problem set 1, and I'll come back to that in just a second. Problem set 2, and I think incredibly important to distinguish as a separate problem, is determining, finally, for the first time, what kind of detention, interrogation, trial policies do we need, do we want, are appropriate and effective for the tremendously important policy task of combating the threat of terrorism. Instead of asking what kind of detention power do we need and how can we best craft that within a system governed by the rule of law after the attacks of 9/11, the question that was asked by policymakers, really often on both sides of the aisle, especially in the years immediately after the attacks, was how can we best balance liberty and security? And while sometimes that needs to happen, certainly, generally, as I think ACS has been saying for the last several years, the broad balance between our liberty rights and our security needs was set by the Constitution some time ago when the United States had never been less secure in its existence, and that it is not at all obvious that liberty going forward has anything necessarily to do with effective counterterrorism. What is effective counterterrorism and what kind of detention policy do we need? Well, I think that's a question that, in the first instance, security policymakers are going to need to answer, but that lawyers and legal scholars can play an important part in providing some guidance toward. So let me, having sort of framed it in those terms, say one other thing about why I distinguish them in those ways, and then just offer a few suggestions along each of those categories. The reason I think it's so incredibly important to distinguish between getting the truck out of the ditch and driving along a good road going forward is because once it became clear, circa 2004 with the revelation of Abu Ghraib, 2005 and so forth, that the policy course we had pursued in these areas was so grossly mistaken and so deeply troubling, Congress's initial response, and the response of many, was to say, well, let's fix Guantanamo, and in the meantime, or along the way, set detention policy going forward. And the result of that in laws like the Military Commissions Act, which was passed in 2006, which was ostensibly designed to fix Guantanamo, but also ended up creating a trial system theoretically for this category of people going forward, was to let the hard case of Guantanamo, which was a mistake and is now broadly recognized as a mistake, set the baseline for detention policy, trial policy, indeed in some degree interrogation policy going forward. It's the classic example of letting the hard case make bad law. We need to not do that, and we need to critically decouple the task of getting the truck out of the ditch from the task of setting policy going forward. Okay, so briefly, a few ways of getting the truck out of the ditch. I think we need to come up very early on with a package of corrections, styled as a package of corrections, of correcting some of these mistakes of recent years. Included in the package of corrections, of course, closing Guantanamo, which we can talk about at length, standardizing interrogation rules. So we've come a long way in improving and clarifying and reconciling the rules the military must follow in the detention and treatment of detainees in its custody. But at the same time, we, the United States, the administration, current administration, has continued to insist upon a distinction between rules the military must follow and rules the CIA may or may not have to follow. That distinction has created, at best, confusion for agents in the field. It has pushed liability down to the lowest ranks instead of allowing actual policymakers and leaders who make these decisions to take responsibility for the consequences of their action. And it has proven, I think, and we can talk about this, more ineffective as a matter of human intelligence collection. We need to standardize and clarify and finally restore our commitment to no torture in those rules. We need to end the program of secret CIA detention, prisons, and we can talk more about that. And not least, we need to identify, make public, and very likely, although this is an action I don't mean to say should be taken lightly, rescind some of the existing ongoing guidance provided by the Office of Legal Counsel in the Department of Justice surrounding some of these policies, some of which memos still have never been made public to this day. So I think there, and we can also talk about the question, and I think we'll probably get to it later on the panel, of what's to be done about people who have committed acts of torture and so forth in the name of the United States in the last 8 years. That package has to come, I think, quickly in the name of both righting the ship, getting the truck out of the ditch, whatever transportation metaphor you want to use, but also making clear to the international community, and most especially our allies, that we are recommitted to counterterrorism under the rule of law going forward. We need their cooperation desperately in order to pursue effective counterterrorism. And that leads me to the last point I want to make. And there are many, I think, aspects of how to design, naturally, a good counterterrorism policy going forward. We'll talk about many. I just want to highlight one in this context. And that is, while there is broad agreement now, I think, bipartisan agreement, that the task of counterterrorism requires all instruments of national policy to be effective, sometimes military, certainly economic, diplomatic, and intelligence tools that we have at our disposal to use within the rule of law. It also can benefit tremendously from the tool of criminal law enforcement, an incredibly powerful tool for securing the long-term and legitimate detention of people who have engaged in even inchoate acts of wrongdoing against the United States and its people and its interests. We have, I think it's fair to say, grossly underutilized the criminal justice system as a counterterrorism tool. I don't mean to be mistaken in saying all of counterterrorism is about criminal law enforcement. That is not my point, nor indeed, I think, many on the progressive side of these issues. The point is that it is an essential tool, and making sure that tool is utilized effectively, is designed currently in a way that allows us to pursue terrorists through the system of criminal justice is, I think, going to be one of the first and most important tasks of a new Justice Department coming in.
Thank you, Deborah. Our third speaker is Tino Cuellar. He's a professor at Stanford Law School, where he teaches administrative law, criminal law, and international law. From 1997 to 1999, he served in the Clinton administration as a senior advisor to the Treasury Department's Undersecretary of Enforcement. We worked on financial crime, money laundering, and terrorist financing and other related issues. He has a J.D. from the Yale Law School and a Ph.D. from Stanford, again, another underachiever up here on the panel. And his article in the package you all have today is called Running Aground, the Hidden Environmental and Regulatory Impacts of Homeland Security. Fascinating topic. Tino?
Thank you, Ron. Let me start by saying that I'd like to thank the ACS for organizing this event. I'd also like to thank my daughter, Ria, who's 4 years old, who approves all my travel. If it weren't for her, I wouldn't be here. And it goes without saying I'm not speaking for her or for anybody else, just for myself. I'm also going to try to place the paper in context. I can tell you a little bit about the punchline involving the paper and in particular the Coast Guard, but I think the issues that ought to be at the fore of our thinking with respect to Homeland Security and are touched on in the paper are broader, and they're dealt with in the work of P.J. Crowley. They're dealt with in some other work that I've done with some co-authors that touch on environmental protection, but also on more generally just what Homeland Security is and where it's going. When my daughter's generation thinks back on how we handled Homeland Security and how we defined it at this point in our history, they're likely to ask two separate questions of our generation. They're likely to ask, how did we deal with the risk of catastrophe? It is an ever-present risk. It is unfortunately not a risk that any one of us can ignore, even if we have a great many disagreements along the lines of what Deborah was laying out with how this administration has approached security. You know, it doesn't take a rocket scientist to see that come presidential elections and transitions, attacks can occur, and we have to be prepared for them. And those responses implicate FEMA, they implicate the collaboration of the Department of Homeland Security with state and local authorities, they implicate chemical facility security in the 14,000 or so facilities that have extraordinarily toxic chemicals that can affect all of us, they implicate counterterrorism traditionally defined. But my daughter's generation is also likely to ask a second question, and that is, how did our generation deal with the potential for slow, steady erosion in the capacity of our nation to guarantee the sort of life that we expect for ourselves? That's a question that obviously touches upon economic and educational policy, health care, but it's also a question that relates to the many functions of the Department of Homeland Security. It's a question that relates to how we protect our crumbling infrastructure, how we deal with environmental protection, how the Coast Guard regulates the cruise ship industry, whether shippers of oil are required to obtain salvage coverage so that if there's an oil spill, we can do something about it in the short term rather than spoiling a huge chunk of our environment. It's a question that touches on whether we get comprehensive immigration reform, for example, that will affect our security by allowing us to reshape the allocation of resources that we have available to protect ourselves. I don't think that those two challenges have been met very effectively. And I think the question of why is an interesting one. It's a question that academics should think about and that policymakers should think about. I think it has a lot to do with scarcity of money and it has a lot to do with political will. But I want to focus more specifically on why, what it means that these challenges haven't been met, specifically what has gone wrong with respect to the Department of Homeland Security. And when I talk about the Department of Homeland Security, I don't want for a moment to suggest that these problems only exist at DHS. I think as I start to read off the list, you'll recognize some things that go back to what Bill was talking about in connection with DOJ, and you'll recognize some issues that really go ultimately to how the White House is organized and what it prioritizes. But think of DHS as a microcosm for the sorts of challenges that the federal government faces. And think of how, when DHS was created, the largest reorganization in history, or at least in 50 years, 200,000 employees being put in one agency, the scale of the organizational challenges were occasionally touched on in congressional hearings and debates, rarely acknowledged by the White House, rarely acknowledged by the first Secretary of Homeland Security, who was someone who neglected for a good number of months to put together a large centralized policy staff, neglected to really look carefully at the extent to which these different agencies were going to suffer by being moved around from one department to another. A second challenge, which is very much related, is the question of money. Why is it that the administration said that they could do this in a revenue-neutral manner? Now, at the end of the day, of course, DHS ended up costing a good deal of money, but the amount of money that it was given to stand up, to start its operations, to transfer the way that the bureaus were engaging in their core missions pales in comparison to what even the GAO said that the different bureaus would need. And to this day, the revenue neutrality point is kind of puzzling when you think about it, because these different bureaus were asked to take on a whole bunch of additional missions compared to what they were doing before. By way of comparison, we spend more on the war in Iraq in a given year than all of what we spend on Homeland Security and diplomacy combined. Third, I would argue that there's been a persistent neglect of regulatory policy writ large. Some of this goes back to the so-called legacy missions, such as the Coast Guard's environmental protection functions, and I'll come back to this in a moment. But we're also dealing with chemical security regulations that were delayed for years, that actually at one point the EPA was interested in pursuing, and in some contrast to the approach that has sometimes been taken by the present administration with respect to legal interpretations that push the envelope. There was concern that the EPA did not have explicit authority to do this. But even after this issue was cleared up, these regulations took a great deal of time. They're still interim regulations. I would argue that they raise some serious enforcement-related issues. The regulations don't really have a provision for auditing the different facilities, and ultimately the resources that have been placed at the disposal of the Department to deal with these regulations are quite meager, about $50 million or so. Then you get to issues involving the narrowness of the definition of security itself. And this is an issue of real historical significance, because if you look back in history, you'll see that there was almost not a single time that John F. Kennedy referred to national security challenges the nation was facing without acknowledging that our capacity to face these challenges really depended on our strength at home. And what that meant, of course, depended in part on how an administration set its priorities. But it's actually really hard to separate the two, and yet time and again in the strategic plans of these different departments, particularly DHS, there's been an effort to define and frame security as counterterrorism in a manner that I would argue helps underscore why we faced such perils when it came time to responding to Katrina. And I think we need to be careful not to show a lack of imagination, A, about the extent to which a catastrophic natural disaster could affect our security in a meaningful sense, and B, about the extent to which even more strategic adversaries might take advantage of those disasters. And finally, I would argue there's been insufficient attention to the rule of law. And here, what I would have to say would overlap a bit with what Deborah has said. I feel like our capacity to get things done, not only with respect to persuading other countries to work with us and collaborate on common security challenges, but also even with respect to convincing the private sector, which of course holds title to 85% of the critical infrastructure that we would want to protect, to collaborate with us and to comply with various regulations and requirements. I think we need to look very seriously at detainees and at the way that shapes the perception of the United States. But I also think we need to look hard at back burner type issues that really do implicate the rule of law and again are inside DHS. And I'm talking here, for example, about the enormous backlogs that are built up at Citizenship and Immigration Services. These are people who are entirely, legally ready to become citizens, have effectively complied with all the requirements, and they're basically in limbo. And of course, that limbo is not costless to us. We approve a certain number of visas, and if people's numbers are not reached by the time that the year expires, those visas disappear. So the Coast Guard. I'll just say a few more words about the Coast Guard to give you a sense of how these individual bureaus can be affected by the organizational and the practical context of where they're placed, who they're under. The Coast Guard's budget for environmental protection, marine environmental protection, was about $250 million at the beginning of this administration. That has now been slashed to the neighborhood of about $100 million. So from $250 million to $100 million. And you can see the effect in a couple of ways. You can see the effect in the proportion of man-hours that are dedicated to environmental enforcement. You can see this in the slow pace at which it's approving health and safety-related regulations, and in particular, the regulation that has been kicking around since the Exxon Valdez oil spill, but that was on the verge of being issued at the beginning of this administration, has been delayed 3 separate times. This is the regulation that would basically require shipping companies that transfer hazardous materials to have salvage-related plans in place to respond to an emergency. And you get the Coast Guard acknowledging, quite frankly, that among the extraordinary challenges they face, which includes, of course, managing the Deepwater Modernization Program, they are simply overwhelmed. They don't have the resources to deal with this, and they've been tasked with shifting their attention away from their environmental mission. This is not to say that the trade-offs that we have to face are easy to make, but it is to say that if we want the Department of Homeland Security and the concept of Homeland Security itself to serve our interests, we have to take a closer look at what it means and what these bureaucracies are actually doing. Thank you.
Thank you, Tino. Our final speaker is Sally Katzen. And Sally, along with her co-author and longtime collaborator Mike Fitzpatrick, did a paper on letting government agencies do what they were created to do. I'm often asked by young lawyers in Washington when they first arrive here, how can I possibly combine a career of excellence in private practice, excellence in government service, with integrity and intellectual rigor? And one of the people I always point to when I get asked that question is Sally Katzen, who really is a landmark for her career both in the private and the public sector here in Washington. She was a partner at Wilmer Cutler & Pickering before she joined the Clinton administration, spent 5 years as the Deputy Director of OMB and Director of OIRA, essentially the Chief Regulatory Policy Official of the United States, then spent time as the Deputy Director of the President's National Economic Council before ending her time in the Clinton administration as the Deputy Director for Management at OMB. She is a brilliant thinker and regulatory policy, and while she is not herself a rocket scientist, I have seen her rigorously question many rocket scientists and bring them to their knees sometimes. So with that, it's my pleasure to introduce our last speaker, Sally Katzen.
Thank you, Ron. And again, thanks to the American Constitution Society for pulling this all together. It really is quite a remarkable project. And I think you're to be commended for the work that's been done in this regard. My focus, not surprisingly, is on the regulatory agencies. And I just need to provide a little bit of context. Congress passes laws and then delegates to the agencies to flesh them out, to provide the stuffings, to put in the fillings of the statutory gaps. If the agencies are precluded from doing their job, or if they are unduly delayed in getting their job done, then the law is frustrated and justice is denied. It's just that simple, and that's exactly what has happened over the last 8 years. The agencies, we're talking metaphors, the agencies have been put out to pasture, they've been suppressed, whatever you want to say, but there have been a number of factors that I think have to be identified. First, the Bush administration has appointed people in top positions at agencies that adhere to the conservative credo that distrusts government, that distrusts not only the actual missions of the agencies they have been put in charge of, but the people who are there to do it. The extraordinary staff who provide the expertise, the analytical horsepower, the institutional memory, the nonpartisan glue that holds the institutions together. They keep them at arm's length. They do not listen. The consequence is that some very good people have left the government. Take a look at the statistics of senior people who are leaving in droves, so that if there is a new administration that has a different attitude, where are the people to do that work? That is a problem. Those who are left are demoralized, unhappy, frustrated, and they will need to be inspired, and they will need to be re-engaged. The other thing that has happened is that the Bush administration has used ideology and politics to trump science and data. Now, I had heard a lot of stories about Bush politicizing science, but when Mike and I did a lit search, I was appalled at the number of agencies that have been targeted and the number of issues that have been corrupted by a decision not to pay attention to the facts, but to follow some predetermined course. And we hear about all of the procedural obstacles that have been imposed on agencies. If you work there and you're trying to get a rule out, you got to check a number of boxes, whether it's data quality, guidelines, risk assessment, peer review, cost-benefit analysis. Look, I love this stuff. I think it's good and it's good government, but only if you have the resources to do it. If you're strapped, if you're flatlined budgets and you do not have the money, then something's got to give. And what's going to give is you're not going to be able to regulate. This is called paralysis by analysis. It gives new meaning to the concept, and it's very real. And lastly, we've also heard about shipping jobs overseas. But are you aware of the fact that they are shipping our government jobs off to the private sector? This is called outsourcing. This is a notion in which, because the private sector is so inherently good at doing things, a notion which is somewhat debatable in light of the corporate scandals and the cost overruns that are often in the newspaper, nonetheless, ship the jobs off to the private sector and let the private sector develop the regulations, indeed write the rules that will govern them, and then, by the way, let them enforce the rules that they have written on themselves. To me, it doesn't seem to make a whole lot of sense, but I think the regulatory agencies are therefore not very healthy and not very happy, and you should see my shoulder injuries and my legs. I mean, I really I empathize with you. What should we do about it? Well, first, we've got to have the right people assigned to the right jobs. It is critical that the people who are appointed in the next administration embrace the mission of the agency that they are going to head and welcome the staff at those agencies. The people we appoint have to be willing to listen and take advantage of the expertise and of the experience that is there. This is particularly important where Congress has decided that decisions should be based on science. We must reconstitute the science advisory boards and panels that have been populated during the last 8 years by people who are not eminently qualified in their profession, but rather espouse or advocate the views of the administration on a predetermined basis. I mean, think about the appointees to the President's Council on Bioethics, just to mention one. And when the agencies do produce good science, it should be disseminated to the public, because that is how a sophisticated people participate in a democracy. Jeff Stone has written a very good paper in here where he talks about the fact that if you suppress information from the populace, you are actually inhibiting democracy as we know and love it. Nonetheless, there are any number of instances where data and findings of a scientific nature have been manipulated or suppressed. Do you remember the stories from NOAA and NASA about global warming, which were edited out not by a scientist, but by a political appointee in the Public Affairs Office? Not a rocket science, I don't think. And finally, when the agencies produce good science and it is disseminated to the public, it should be the basis for decisions. It should not simply be ignored. Remember Plan B, where the advisory committee to the FDA was unanimous about its safety and efficacy. Too bad, not matter. Or the next standard, the environmental standard on clean air, where an advisory panel talked about how it should be formed. But the president, who has not had a lot of courses in environmental policy, as I understand it, thought that he was in a better position to determine the format of the NACs. We obviously have to provide the agencies with the resources to do the job we are asking them to do. And this is particularly the case with health, public health, with worker and consumer safety, and other kinds of basic quality of life areas. And finally, there is this issue of outsourcing. It has got to be put on a sensible track. It is really important that these agencies not only have the resources and have the people, but understand that they are on the right track. Otherwise, it's a huge loss for those of us who care that the air we breathe and the water we drink is clean, that our food and our drugs are safe and effective, that our workplaces and our markets are fair and competitive, and that our financial institutions are sound. Do I need to say anything more about what happens when you don't have good oversight with our financial crisis today? In any event, look forward to your questions, and I thank you.
Thank you, Sally. So now we're ready for questions, and I think rather than I have a number of questions. Rather than putting them in, I think we'll go to the audience first, and I'll fill in as we go along here. I'm asked to call on members of the media first, and if you have a question, please wait till you get the microphone before you ask your question, so we'll have it on tape. And also, please identify yourself when you ask your question. So, journalist, Stuart? Right there.
Hi, thank you all for your presentations. Deborah Pearlstein, I have a question on interrogation, which you discussed. Congress, as you know, in February voted that the CIA should have to comply with the Army Field Manual, and the President vetoed that. My question is two parts. First, was Congress right? Is that a good idea? And second, am I correct in understanding that the Army Field Manual not only bars the list of harsh techniques we've talked about, but bars any coercion or any intimidation? So, for example, yelling angrily at a detainee would violate the Army Field Manual. And is that a good idea?
Thanks for the question. So the first part, was Congress right to require or try to bring CIA in compliance with essentially the same rules that the Army follows? I think broadly the answer is yes. Now, does it have to be the Army Field Manual, you know, to the last jot and tittle? Not necessarily. But the critical dispute that the administration continues to sort of pursue and is behind the veto of that bill is that while torture, of course, is something we never do, techniques that would otherwise be characterized as cruel, inhuman, and degrading treatment under U.S. and international law may actually be okay under certain circumstances. And among the techniques included in that category most often are techniques like waterboarding, which some people describe as simulated drowning. I would describe as mock execution by water. In other words, there is no simulation about it. You are drowning, and they may or may not stop in time. So that's the nub of the debate. Now, the Army Field Manual, I think, is very good in actually broadly, although I don't agree with it in every aspect, broadly accurately reflecting the U.S. commitments under the Geneva Conventions and other international legal instruments against both torture and cruel, inhuman, and degrading treatment and punishment. So, again, with a few exceptions, the Army Field Manual is a good model of this, written and considered by some of the same people who reconsidered the Army Counterinsurgency Manual that's now produced, I think most would say, a great deal of success. So, broadly, yes, you know, there are other ways around this, but the prospect that we either A, continue to equivocate on cruel, inhuman, degrading treatment is okay, including mock execution by drowning, it is a failed policy decision and contrary to law. And two, that we continue to pursue a bifurcated set of standards. So while you have this era of counterterrorism that requires incredible interoperability between military forces and intelligence forces, you've got these guys in the same room together, but one guy can follow a certain set of rules and the other guy can follow another set of rules. That is a recipe for disaster. That's part of, not the only thing, but part of what led to Abu Ghraib and associated things. Now, just briefly, does the Army Field Manual categorically prohibit anything one might consider coercion in any way? No, I don't read it to prohibit coercion altogether. It lists, you know, there's some, I can't remember how many, 14, 15, 16 different techniques that many might define as coercive in some measure or another. Now, you know, is lying to a detainee and trying to trick them into telling you something a coercion that is something human rights advocates would celebrate? Not necessarily. Is it potentially lawful under Common Article 3 of the Geneva Conventions? Yeah, potentially. So, you know, there's room for discussion on some of that. What there's not room for discussion is either cruel and inhuman degrading treatment and a bifurcated method of continuing.
Thank you, Deborah. Another journalist question? Right here in the front row. We'll work our way back.
Hi. This is a question for Bill Yeomans. I'm Carrie Johnson from The Post. I'm interested in, given the fact that the Justice Department Inspector General has declared in at least 3 reports so far that hiring and employment at that department has been politicized beyond most measures over the last 7 or 8 years, how a new administration roots into those ranks without being perceived as unduly political itself.
Yeah. It's a really good question, and a very difficult question, I think. It's going to be a challenge for the next administration. Obviously, the people who've been hired as career people have regular civil service protections. Any broad-scale effort to root those people out is going to raise morale concerns among the civil servants, and that's, I think, not something that anybody should be trying to do at this point. The civil service has suffered enough. On the other hand, I think that there are remedies that can be pursued, and there's a legal question about what can be done. And I don't know at this point the full answer to that, but certainly there is some argument that those appointments, if they were based on inappropriate considerations, were unlawful. But putting that aside, one way to deal with those people certainly is to lay out very clear priorities, and then to enforce a very rigorous performance evaluation process. And I think that's a good thing for an organization in any event. And it seems to me that to the extent that incompetent people have been brought in through this politicized process, they can be identified that way. It does seem to me that there are probably a fair number of people who may leave, people who really came on a political mission. If that mission is no longer being served by their being there, may go on to greener pastures. It may be that there are people who were hired through this process who are actually very fine attorneys and want to stay and do the work of the Justice Department and Civil Rights Division, in which case that's great. There are other things that can be done, though. I mean, certainly within the division, for example, there have been management decisions made. People have been promoted. People have been given assignments. People have been put in very sensitive positions in the voting rights section, whatever. Now, it seems to me that if those people have been hired through a politicized process, and if they are either unwilling or incapable of carrying out their assignments, then there is a great deal of latitude among management to move people around. And that's certainly something that needs to be considered. There's a corollary problem, and this is following up on something Sally was saying, in that there are just there need to be there are a lot of people who are going to need who are basically incompetent in their jobs at this point. And so I think that it's going to be very important to focus on those people and to do it through a rigorous performance evaluation system. So I'll leave it there. But I think it raises serious morale concerns, and I think whoever does this has to do it in a very sensitive way.
What a fine example of what a genteel, wonderful gentleman Bill Yeomans is how many times it took him to get to the sentence, there are incompetent people in the Justice Department. But he did get there. Next question.
Stephanie Metzmer from Mother Jones Magazine. This is really to anybody on the panel, but I'm wondering about, since you've been talking about the transition, that whoever takes the White House January 20th may become the defendant in different types of litigation, or people challenging the legal decisions of the previous administration. And how does that person change course if they want to? Or does that create enormous problems, if you don't agree what's been going on with the Justice Department and you want to fix it, but yet as the government you are the defendant in those cases? How do you get out of it? Can you do it? Will it take a long time for all of this to happen? If you could talk about that broadly, that would be great.
Sally, you're an administrative lawyer up here. You want to start with this?
This was more of a litigation question. I was going to yield to that. But I can tell you that an administration steps into the suit and is then asked to plead, and there have been lots of occasions where changes have been made in the pleadings which take a different tack than has been taken before. Now, the individuals who were in the previous administration would have a great interest in how these cases are resolved, and they may have standing to be able to contest some of the changes and assert their own defenses. that becomes very complicated, and I would defer to the Department of Justice to defend those.
Can I just add two brief things? This is sort of related to the issue you're raising. One is kind of just a more political and practical observation that this is kind of related to Ron's point about how everybody feels like they have got the worst injury. So managing expectations is very challenging here because it's such a huge, massive apparatus. If you look at litigation as well as regulatory actions, that it takes a huge amount of time to actually change everything that there are expectations that a new administration would change. And that might apply on, both sides of the aisle. But the other point, which is more of a technical legal point, which complicates things, is that a number of circuits have increasingly raised the standard at which they will evaluate arguments from the government when the issue is whether to rescind a regulation that has actually gone into effect already. So there's kind of an asymmetry here with respect to what is required to decide to withdraw a regulation that has not become final, and then what happens once it's final. It's certainly not impossible to change, but it's a lot harder. It takes a lot more evidence and determination and whatnot, and that, of course, complicates things too.
Let me just quickly say that obviously a new administration coming in can change a litigation position, but it's not something that should be done lightly. It should be done in extraordinary circumstances, and it needs to be done only on the basis of a disagreement with the law, I think. Anything else will appear to be the kind of a politically based law enforcement decision, which is the very thing that many of us are complaining about. So it's not completely off the table, but it's something that needs to be done very carefully and with a full legal justification.
Okay. Other questions from journalists before I open up more broadly? Yes.
Ken Jost with CQ Press. The Supreme Court handed down two very controversial decisions on its last 2 days, abolishing the death penalty for child rape and endorsing an individual right to guns under the Second Amendment. Senator Obama's reactions to both, criticizing the first, endorsing the second, aligned him with the court's conservatives, not the court's liberals. With that kind of as a background, I wonder how each of you would expect the current frontrunner in the presidential race to perform on the policies that you've described.
What's the start?
I don't know.
Well, I got this off of my own personal view. I thought on the question kind of most directly related to this, which is the selection of judicial nominees, I actually was quite pleased to see that this question got put to both presidential candidates last night in a presidential debate. I think it's it's obviously not a question necessarily that's front burner with every voter in America, but it is a very important question, and it's great that it gets national exposure in a presidential debate as it did last night. And I thought Senator Obama's efforts to address it and explain what he's looking for in judicial nominees and the approach he'll take to this issue, particularly around the issue of choice, but I think more broadly, it's laid out a very mainstream progressive point of view that I think will be what guides him here. And there's no question that Barack Obama is not just someone who cares deeply about legal policy and matters, but is an accomplished lawyer and constitutional law scholar himself. And I think he'll bring that sensibility and that approach to the White House if he wins. Senator McCain, I had the pleasure of seeing him in action when I worked on the Senate Judiciary Committee and in the also in the White House and whatnot. And he is someone who, early in his career, had a little more of a middle of the road position on some of these legal issues. But as his career has progressed and perhaps as Republican politics has moved, he's moved a bit further to the right. And I think that he has said that he will pick judges in the mold of Chief Justice Roberts and Justice Alito, and I certainly take him at his word on that. I think there's obviously a very big difference in direction in the direction these two gentlemen would take if they became president in areas of legal policy and particularly in the area of judicial selection.
Can I add maybe just one thought to that? And that is, with respect to understanding the decision about, I can't begin to speculate who Barack Obama or John McCain would pick for the Supreme Court. But with respect to understanding whether or not a decision like the death penalty decision you're referring to makes sense, I think there are good and persuasive legal reasoning decisions and decisions that are less persuasive. And while I would say I'm the last person probably to defend the death penalty after a year clerking at the Supreme Court and seeing these midnight last-minute appeals after appeals, I think it's very difficult to come away with a perception of that system that is otherwise, that is other than catastrophically broken. So I am no fan of the death penalty. At the same time, I looked at that decision and the way it was written and supported, and I thought, based on the way the Supreme Court has viewed categorical decisions about the death penalty in the past and how it's treated those questions jurisprudentially, this was a less persuasive decision. And if the question is, how are we going to begin to remedy the problem of viewing of having no distinction between questions of law and questions of policy, having judicial decision makers who, with the rigor of a constitutional law scholar who takes law seriously as its own independent discipline, having justices who not only have their hearts in the right place, but their legal reasoning skills up to par, I think is going to be something that I would hope would be incredibly important and front and center in any judicial selection process. I expect that it would be.
Just one small note of reality from the Hill. Obviously, whoever is selecting judges will have to take into account the composition of the Senate and the ability to get those judges confirmed. I'm not going to speculate on what the Senate's going to look like, but certainly if one party has an overwhelming majority, it's going to be much more difficult for a president from the other party to move extremely far in the other direction.
I see Stuart and Elliot in the front row pondering that for quite some years of experience. The wheels are turning. Other journalist questions before we open it up to other questioners? All right. Well, then, let me open it up a little more widely, and we'll get this gentleman's question, but also, particularly if any of our authors who are here have questions or comments, I'd like to give them a chance to say something. But this gentleman's been waiting, so we'll go with him first.
Hi, I'm Steve Chernowski. Professor Coyer, I just wanted to commend you on an excellent piece looking into and with all of the things going on in DHS, a very oft overlooked thing. I would encourage any of the law students in the audience looking for a topic for a note or comment to give similar treatment to the Department of Agriculture equities that moved over to DHS, Plum Island, and the PPQ inspectors at the airport. I just would like to highlight two things that I think, that at least I see, that maybe could have made the article, I think, that also have an impact on the Coast Guard's regulatory function. One is something that very few people are aware of, is the perennial Iraq mission. Several hundred Coast Guardsmen have been on Iraq duty since the very beginning of the war, and that has had a real and serious degradation on their manning. And the other is the use of the Coast Guard by DHS headquarters and other components, almost as a crutch, to rely on their commissioned officers to basically provide and fill out a level of bureaucratic and administrative expertise which may not be resident in the appointee ranks. Thanks.
That's an excellent point. If I could just add, so that plays out in two ways at least, and it's definitely worth highlighting more. One is, of course, with respect to the human capital of the Coast Guard, right? The experience of the people who are being deployed to these other functions is missing where it has historically been. And then the other, of course, is with respect to budgets, which makes it so that even the relatively meager increases that the Coast Guard has finally gotten, aside from the deep water stuff, really end up not meeting the needs it has.
Great. Questions or comments from our authors who may be here today before I go more broadly? No? Their written work speaks for itself then. All right, other questions or comments from the audience? Here, I saw a hand in the back there.
Hi, I'm Ian Milheiser from the National Senior Citizens Law Center, and I guess this is principally a question for Sally, although if other people have insight. The administrative agencies have been very much taken by business interests, in many cases promulgating rules at the direction of business interests. You know, probably the most egregious recent example of this is a drug company named Wyeth has a very important case in front of the Supreme Court. and the Food and Drug Administration literally looks like they took language from Wyeth's brief and made it into a rule, which is now a new Food and Drug Administration regulation. My question is, let's say that at 12:01 on January 20th, the next president issues an order saying that he wants to root out every single case in which the present administration went and at the direction of a business interest changed a rule to the benefit of that business interest, and they began finding those rules, and then they began the notice and comment period. How long? How long would it take if all that they did was try to change things back to the way they were under the prior administration?
How long do you have for my answer? Actually, it's not as dire as it may sound. Traditionally, and by that I mean the last two presidents, have come in and at 12:01 on January 20th have issued a stop order. And that stop order tells people in the agencies, if you are about to finish a regulation and or even you've sent it to the Federal Register but it hasn't been published, stop it, pull it back, forget it. And we're going to review those before they become final because it has to go into the Federal Register. So you can stop things in process. Things that have become effective in the last 60 session or legislative days of the Congress, not calendar days, but session or legislative days of the Congress, are subject to review under the Congressional Review Act, which would allow a motion for disapproval to be filed in either house, voted on in the other, and no filibuster allowed in the Senate. And those can be disapproved during that period of time. So if there is an egregious situation, an objectionable regulation, they can go before the Congress, and the Congress can say, we don't like that. Now, it has to be signed by the President. The Chadha case does maintain good law, and so you would have to have a Democrat, for example, in the White House, Democrats in control of both the House and the Senate. There are also appropriation riders that can be used. Every president calls for clean appropriations bills. They don't want any substance. They just want the money. But traditionally, they have been able, the Congress has placed riders on appropriations bills that say no funds authorized herein shall be used to enforce a particular regulation, in which case the agency is not going to be able to enforce this regulation as of that moment that these become. We've got a continuing resolution, as I understand it, that's out there, and by March 9th or something, there's going to have to either be an addition, addendum, or whatever, and an appropriation. In other words, there are a variety of ways that you can do to root these things out. I remain confident that we could get them all.
An air of optimism. Other questions? Yes, over here.
Lee Garrison, retired federal attorney.
Wait 1 second till they get the microphone to you, if you can. There you go.
As I'm thinking about all these things that I've said for quite a long time, I can name practically every major agency of government that I've disagreed with and things they've done in the last 8 years that have been so objectionable. But it took them 8 years to do it. And so I'm thinking should we really be turning the clock back to 8 years previous, or should we find a new way to approach and prioritize? Because while we're all concerned with many of these issues that have been discussed, you also have the pulse of the American people, who these days are really concerned with the economy and security. And I don't think we can lose that focus, and at the same time, all these little things that we'd like to change, I'm sure the other side is going to try to come up with stumbling blocks and lawsuits, et cetera, et cetera. So how do you address and prioritize an agenda of a new administration in the first year? I guess is my question.
Deborah, what about you?
Okay. I think priority set, for what it's worth. I think priority setting is going to be a terrible challenge for the incoming administration. I was thinking in response to this question earlier about what do you do about pending court cases, and a new administration comes in and wants to, make a new decision. We still currently have 200-some pending detention cases out of Guantanamo Bay alone. And this is this one, albeit I think significant, but one, outpost of U.S. operations. I think it's going to require some pretty impressive management, and the groundswell for transition planning now, that at least, I've sort of heard, arguably on both sides. I think there's more activity on the Obama side, but I just don't know much about the McCain side. I think is incredibly important. But when people talk about, wartime transition as the reason why it's important to, get our ducks in a row now, that's important. Certainly, we have ongoing conflicts in Iraq and Afghanistan and so forth. But that's not the only, that's not, I think, the principal reason that should drive early presidential transitions. The principal reason is you want to know what the priorities are by January 20. Even if you're not doing anything about them yet, you want to have a to-do list. I can't imagine a new administration coming in on either side and not having the economy as issue number one. I think for my own set of issues, if we spent a year getting the truck out of the ditch and accomplished a significant amount, we'd be in tremendous shape. I think it'll be, if we're incredibly lucky, year two before we're in an affirmative mode in these issues, and at the same time, emergency in resolving and being prepared for emergencies that might arise, and in fact are most likely to arise before you've got things up and running, is something that has to happen simultaneously. So, I'm guessing there I've just said, terrible priorities. The economy, emergency preparation and planning. And I would say, pick your 4 or 5 most catastrophically bad decisions and do those first, and probably in that order. It's going to be tough. I don't envy your job.
Not me, man. Tina, would you like to add anything on that?
I would just briefly, I'm tempted to answer the question by just saying yes and not saying anything else. But I think Deborah's right, and I'll just kind of frame a concern more than directly answering questions. I think it's very difficult in the abstract. But I'm fairly confident that any new administration can keep an eye on 2 baskets of things. There's continuity of government and the economy, and a very select few issues that are not deferrable for a minute. And then there are getting out of the ditch issues, which are deferrable for weeks, months, maybe not more than that. And I have great confidence that those are going to be front and center. And they're different, but both are going to be important. I guess the challenge from my perspective would be recognizing that there are deeper structural issues and longer-term policy issues that are extraordinarily important, that go in part to what's happened over the last 8 years, but go in part to issues that have been unaddressed for 20, 30 or more years. And on the one hand, I think it's very difficult to give them the same priority that these other 2 categories of issues will get. And yet, the trade-off is some of them require 2-3 years to get traction on and get done. And in some cases, we're even talking about things that seem pretty easy to do, like structural changes in DHS. Why don't we have a regulatory policy coordinator to take a look at what's going on at the Coast Guard day in, day out, for example, to make sure that the environmental policy functions don't get completely shifted aside. But these are issues that take time away from the priority issues I described. They require coordination with Congress. And then if you work up to bigger issues like immigration reform, I guess what I would say as a concern is to make sure that there's a recognition, whomever gets to be in the White House, that these extraordinarily high priority issues have to be managed in part by still carving out time for the longer term strategic goals.
And if I could just real quickly, it does seem to me too. Obviously it's possible to do more than one thing at a time, but to the extent that the work of the administration is rebuilding the institutions of government, making agencies functional again, getting competent people in place, reestablishing, the processes that make institutions work well. That has to happen in order for us to be able, or anybody to be able to carry out an agenda. So it seems to me that's laying the groundwork, and you can't leave that aside. That can't wait. And you can do other things while you're doing that, but I don't think you can do a good job of implementing priorities until you have capable people in place and institutions functioning properly.
Amen.
I think we have time for one more question. So there's a question in the back over here.
Patricia Lee, attorney member of ACS. Thank you for this very informative discussion on law and justice policies. My question relates to, again, this economic crisis that we're in. And I was wondering whether a lot of the discussion is transferable to other agencies, whether it's, or organizations such as the Department of Commerce or Small Business Administration or Office of Management and Budget, and how they might be reformed or changed or in the new administration.
Sally, I think that is right up your alley here.
I think that the lessons that we learn from the regulatory agencies are lessons that we can apply to the other agencies. I think, as Bill was saying, it's the personnel on top, having the right person in the right job, having the right approach to the mission of the agency, whatever that mission might be. I think the kinds of things we've been talking about here, which is, at bottom, good government. It's carrying out the will of the people and the law of the land and providing justice is at all of the agencies. And some of the things that have been mentioned, I was sitting in, as I heard my co-panelists talk about things, thinking, yeah, I can use that in the regulatory agencies too. They're transferable, and I think the lessons to be learned are clear, and the way going forward is obvious. We just need the political will to do it.
Well, I think that's a fitting end for this panel, our wonderful end. I want to thank everyone for coming. Again, I want to thank Lisa and Judy and the ACS staff for organizing the fantastic volume that you have. Obviously, the authors who are here, and I hope everyone will join me in thanking our panelists for a wonderful presentation.
Yeah, I'd still teach the course if you don't.